there was enough there to keep digging. And so we kept digging and we pressed, and now we were convinced that the four witnesses, even though they were unanimous, were wrong. They weren't lying, they were just mistaken, and we had to show that somehow.
This is Courtroom Stories and Tactics by RVA Trial Lawyers, hosted by Sharif Gray and Neale Abuzaki.
All right, before we get into today's episode, I want to take a minute and thank Maximum Medical Improvement Partners, MMI, for supporting the podcast. As many of our listeners know, one of the biggest drivers of case value for our clients isn't just proving liability, but it's whether the client actually gets the right medical care and recovers from their injuries the right way. As we all know, when their treatment is delayed or incomplete, their cases lose value. And Maximum Medical Improvement Partners helps solve that problem.
You're right, Sharif. My name is Dr. Scott Dickey, and I'm with MMI Partners. Our mission is to connect injured clients with the right clinicians and quarterback the client's medical care from day one, leading to stronger recovery, clearer documentation, and increased case value.
Thanks, Scott. For our listeners who are interested in getting in touch with you all, how can they find you?
You can visit us at mmi.partners. Again, that's mmi.partners.
All right, we're back. And today we've got a special guest, Jim Neale. So Jim and I go back quite a ways, actually. So I went to UVA, graduated in 2014, which was only a couple of years ago, right? And actually what's insane, Jim, is like now I think I just hit, or I'm coming up on 12 years as a lawyer. So at some point I should actually start learning and figuring out like what to do. But I feel...
Don't figure it out, Sharif. An old lawyer told me once, there's nothing scarier than a young lawyer with a law book under his arm.
Yeah. No, I get it. And I mean, that's why they call it the practice of law too.
It's a practice.
And frankly, I think in all seriousness, once we think we figured it out, it's probably means it's time to hang it up, because the practice of trial work, right, is always evolving.
If you're telling yourself that, you're deluding yourself. But
well, thank you, Jim. So I took a trial ad course at UVA, the National Trial Advocacy College, if I remember that correctly, would run by Steven Salzberg, I believe, professor at GW, would put this thing on. And it was hosted at UVA, but the primary participants were lawyers at other law firms. And because it was hosted at UVA, there was a deal where I think it was like for $250, which is a massive discount off what the sticker price is for the thing. The students got to go and do this course for the week or so.
And pick up a credit too, I think, right?
I think so.
Yeah.
I think so.
Probably your best grade in law school.
Maybe. I don't know. I mean, yeah, because it was pass-fail, right? But it's amazing to me, like, one, how that course has kind of impacted me. I remember getting the free book, which was the book by Herbert Stern and Steven Salzberg, Trying Cases to Win, in one volume. That, by far, in terms of like classic trial ad books, in my mind, there's nothing better. And so I remember getting that book there. But then, related to this conversation, you were one of the two professors, I believe, who were tasked with or were assigned to our section. And I still remember you demonstrating a cross-examination and just how natural it was and how you did it. And I was like, one day, I hope I can do something like that.
I wish I had the same effect on jurors, Sharif.
You have, Jim, and we'll get to that. So, and anyways, I remember we had lunch at one point on the mall in Charlottesville. When I had my big law, should I call it a vacation, or I don't even know, or blip, whatever it was. I'm glad I had
frolic and detour.
A frolic and detour. We spoke very briefly, and then we, of course, we saw each other at the VTLA convention not long ago. But Jim, great trial lawyer, gives his time to help others learn, and now you've gotten into mediation. So before we go down talk about some of the stories that we want to share today and lessons learned, why don't you take a minute or so and introduce yourself?
Well, thanks, Sharif. I appreciate you having me here. This is I've enjoyed listening to the show a few times, and I'm really glad to be on it. I have practiced law since 1998. I went to UVA. Before that, I spent a few years in the Army, which is something else I think we had in common.
That's right.
And
but you did like
over.
Real stuff in the Army.
Well, people who are still talking about what they did 30 years ago haven't done much lately, Sharif. That's
Understood.
A good rule in life.
Understood.
So.
I was just one of those lawyers who was being a pain in the ass to everybody. But no, actually, Jim's not giving himself enough credit. You're an Army Ranger.
I was in the Ranger Battalion. I had the best job in the world. I was a rifle platoon leader in the 3rd Ranger Battalion.
That is awesome.
It was an awesome way to spend a couple of years.
Awesome.
Leaves a really good mark on you, as you know from what you did. But went from there, knew I didn't want to stay in the Army forever and wanted to kind of settle down in one place and raise a family. And someone was asleep at the switch at UVA Law Admissions, and I snuck in there and spent 3 years, and then clerked for a judge here in Richmond, Dick Williams, who was kind of a legendary trial lawyer himself from another generation, and went back to Charlottesville and stayed there for almost 30 years with McGuire Woods, and just left at the end of last year, and I'm now with McCammon mediating cases instead of slugging it out in court trying to help people resolve them.
Going to mediation like the same thing or the similar to when, you know, how like judges who can't retire, they go from active instead of retire to senior status where they make no more money, but they just stay busy.
Yeah.
Is that, or I'm joking, obviously.
I don't want to speak for a lot of judges. So in my class this year, there were 6 of us and 4 were retired jurists, and they're really good at what they do. And a lot of people need judges to mediate their case for different reasons. But I think some cases and some lawyers would rather have lawyers do it. And I'm amazed at how much more experience you have as a lawyer mediating cases than you do as a judge. Judges aren't really used to negotiating, right?
That's right.
They rule and they tell you what's going to happen, and it happens. And it either gets affirmed or reversed, but that's the end of the story for them. And I think sometimes mediation requires something different than that. So hopefully I'll be able to bring that to the table. But I thought it was a way to stay involved and stay connected to something I really enjoyed doing on a different level and at a different pace.
Yeah. Still billing hours though, right?
Yeah, still billing hours, but there's a lot less pressure.
Yeah. Not every 6 minutes. No.
Not every 6 minutes,
There we go.
And no targets. They'll let you do what you want to do.
I like it. No, that's awesome. We'll have to, at some point, we'll have to figure something. Well, when our firm does choose to mediate, which isn't often, but we're warming up to the idea, we'll have to get you involved. And I do see, not to take us off track, but I do see a lot of value in, especially lawyers with, at least from our side, with significant experience in the defense serving as mediators. As I mentioned, Stan Wellman is a friend of mine, and I think a great lawyer in his own right, and a great mediator, and he's typically our first choice when it comes to mediation.
Stan's really good. His partner, Mark Nanavati's doing it now.
Yep.
And is going to bring a healthy perspective to that as well. And I think if you're a plaintiff and you're willing to choose a defense person as a mediator, or you're a defendant and you're willing to choose a plaintiff's lawyer as a mediator, or a judge with maybe a different reputation, that speaks really well. And there's no reason you shouldn't. No mediator is going to make you do something you don't want to do. So,
right.
But I think it puts the other side at ease a little bit, and I think there's a lot of advantages to that if in the right case.
Absolutely. Well, before let's take you back to a case that you handled a number of years ago, involving a pretty horrific collision on 64. Can you tell us kind of what was going on with that case?
Yeah, really, really tough case. So those were the old days. When big law firms still were doing some insurance defense stuff. And I was very lucky to start at McGuire Woods at a time when, as a young associate, I could occasionally work on the big case that was fun and exciting and maybe in the newspaper. But far more often I was doing a supermarket slip or fall, or a rear ender, or this was about 10 years into my practice. And this was a case where the insurance company for a big company here in Richmond, a Fortune 50 company, had an executive coming back from a sales meeting in Mexico, and he landed at Richmond International and was driving home late at night. So he was going from the east side of Richmond to the west side, and head-on collision on 64, 2 SUVs at highway speed. Both drivers, fortunately, were alone, but both drivers died. Terrible fire, terrible collision. Late at night. Lots of witnesses, and all the witnesses said uniformly that the white car was going the wrong way and the red car was going the right way. And unfortunately for my guy and his widow and his 4 children, he was driving the white car. And so 4 witnesses put him going the wrong way, even though that story didn't make a lot of sense to us on the surface. So we had our work cut out for us in the case. We were a defendant unwillingly in a wrongful death case.
And I know we'll get to that, but you eventually, you filed a counterclaim, right?
Which you don't usually see, right, in a wrongful death case.
No, not at all. And what's interesting, and I used to do it, I did a lot of criminal work. Ironically, I've only been a personal injury lawyer for 4 years, which is crazy to think that our firm's done what we've done. But I did mostly criminal work beforehand. And one of the things that I would notice, and I think it's not just exclusive to criminal law, but the police report is often considered kind of like the North Pole, right? Like the police report isn't really scrutinized. It is what it is. That's what happened. And kind of we just take that as gospel, right?
Written in stone. That's
right. And I know with the case that's on the criminal side, and we see it even here on the civil side. Well, the police report said this. And so once the police report is not in your client's favor, it is, as you know, an uphill battle to get people to change their mind.
Really tough. And I don't blame the state trooper who filled out the report, right? He had 4 witnesses all telling him the same thing. It was
of course
2 a.m. His shift. He wanted to get home safe to his family. He didn't cut corners or take shortcuts. He just wrote down what he was told, and from what he saw that night, it probably made a lot of sense. And but it turns out that he, I think, had the wrong guy going the wrong way, and the wrong guy going the right way, and the right guy going the wrong way.
Yeah, and it's so Virginia is interesting in the sense that like we don't allow for accident reconstruction testimony typically. That's whereas in other states, and I know colleagues I have in other states are like, huh, that's crazy. They'll have the police officer take the stand and they'll say, yep, you're an expert. You've been doing all this stuff. Well, tell us what happened in this car crash, right? And Virginia doesn't allow. And I actually I don't know what that would be like with that type of testimony allowed. I like it because at the end of the day, like if police officers are not watching what happened, they're just coming and doing an after action sort of gathering of the facts and doing the best they can to try and figure out what happened.
I think it's almost an advantage. And I think it's a little bit like the contrib rule. On paper, the contrib rule looks like a real problem for plaintiffs.
Right.
I think in reality, it's jurors treat it differently. And I think the rule about accident reconstruction looks like something on paper, but the truth is, and this trial was a good example, you can reconstruct the hell out of an accident, but you have to do it with the jury. You can't beat them over the head and tell them what happened.
Sure.
But you can give them all the tools they need to reconstruct it themselves.
Exactly. And that's, frankly, to your point, that's more effective.
It's always more effective
because you're not bringing in the expert to say, well, just look at this expert and he did his own analysis and just trust that guy, right?
If you do that, you're going to have jurors who accept that. You're going to have jurors who reject it. But if you give them piece by piece and you let them come to their own conclusion, then they're going to go back in the jury room and they're going to fight like hell for that position.
Absolutely. Well, tell us, how did you get involved in this case?
So it was a big company. It was in the days when GE had a real presence here, and I think it's probably been long enough. I'm not divulging any client confidences here, but so this was a GE executive.
Got it.
And we were doing General Electric work and GE Fanuc work in Charlottesville, and so they knew where to find us. They had their sort of captive insurance company, and as a result, the case landed at McGuire Woods.
And was this the typical type of case that you would handle at that point in time at McGuire Woods, or you specifically, like, what was your practice like then? How did this case find itself on your desk?
Yeah, that's a good question. I think when I started, I was nominally on the General Motors team. So we were defending auto manufacturers against product defects.
Okay.
And there would be, we did a lot of seatback cases. We did a lot of fuel-fed fire cases, real serious injuries, real big client. Kind of, they really knew how they wanted cases handled. So I was used to the reconstruction principles, and I was used to tort law, and it was halfway to Charlottesville, so it was in my neck of the woods geographically. But I didn't spend all my time on that stuff, and I filled it with a variety of really sexy supermarket slip and falls, and basic rear enders, and all the stuff that today insurance defense firms do.
Got it. You get that case file. I'm sure there's some sort of conversation about what the expectations are, but I'm sure one of the first things you do is you see that police report.
See the police report and think, man, we got our work cut out for us here. Why aren't we resolving the case. And the employer, to its credit, and the insurance company for the employer said, it just doesn't smell right. This guy's coming from the airport, driving west to Goochland. He doesn't drink. He's sober. He's got toys. He's got presents for the kids in the back of the car that he bought in Mexico that they found afterwards. He'd called his wife halfway home. There's no reason for him to be going the wrong way on the highway. And so you know, that initial phone call from the client, you hear it, and sometimes it turns out to be correct, and sometimes it doesn't. But talking to this man's widow, there was no way you could hang up the phone with her and think that her husband had made a mistake like that. It was a route he'd driven 100 times. He was a high-functioning, smart, capable guy, and he wasn't suicidal. He wasn't drunk. It was just inexplicable. So,
Yeah. No, and imagine if I'm in your shoes sitting there, I'm like, okay, I've got this widow, I hear this story, but then I got this freaking police report and I got 4 eyewitnesses.
Right.
Like, what am I going to do? Right. I mean, once you started getting to work, when did you get to a point where you're like, you know what? I think they got it wrong.
So I remember a couple of events. It was long enough ago that I don't have the timeline perfectly straight, Sharif, but I remember
So we can
a
make
couple
it more
of events.
favorable,
Yeah,
right?
exactly.
That's how
I can
that
fill
works,
in the
right?
gaps.
Yeah.
Which is a big part of this story, because we all do that, right? We all remember things that we want to remember, and we don't remember the things we don't want to remember. But I remember, even though accident reconstruction is not allowed in Virginia, if you've got a big car collision case, truck collision case, it's a mistake not to hire a reconstructionist. And we did that. We hired somebody who helped us out with our automotive product liability cases. And he came up and he looked at the scene of the accident. And he found one of the cars was a Ford and one was a GM. I think we were driving the white GM. The other guy was driving the red Ford. And a lot of the debris was still on the side of the road and in the median. And I was a really lousy science student, but I remember that objects in motion tend to stay in motion, right? And so the Ford was throwing things in one direction and the General Motors car was throwing things in the other direction. And the expert was able to walk along the median and find a hubcap or a light piece or a grill piece or a hood emblem. And he really convincingly mapped it all out and said, look at this. The Ford is obviously going east to west because all the debris is westward. And the General Motors car is obviously going west to east because it threw stuff in that direction. And I don't think the cop got it right. And it was late at night and those witnesses were far away, and I'd really like to talk to those witnesses. And so there was enough there to keep digging. And so we kept digging and we pressed and we were privy to our guy's blood and alcohol, which came back clean. And we were really curious about the other guy's blood and alcohol, and we kept pressing, and lo and behold, he had a lot of alcohol on board. And now we were convinced that the 4 witnesses, even though they were unanimous, were wrong. They weren't lying, they were just mistaken, and we had to show that somehow.
Did you speak with those, and I think I know the answer, but did you speak with those witnesses during the investigation part? And if so, kind of what was that like?
Yeah, we did, or we tried to. Not everyone wanted to.
Right.
And at first it was a really light touch, Sharif. You know that dance, right? You don't want to be overbearing. You don't want to, because everybody gets defensive in that position.
Absolutely. People double down.
Because
now it's no longer about the truth. It's about ego.
Why
right?
are you
And we all
threatening
do
me?
it. Yeah.
Of course I saw what I saw. And so one of the big lessons of this case for me was talk to the people who are willing to talk to you on whatever terms they're willing to talk to you. And then, if you need to later, there'll be a deposition and you can drill down on details then, but don't press it. Don't show up at their house and knock on their front door unannounced. Don't invite yourself in, do it on their terms. And when you do that, they're a little more comfortable and they'll not let their guard down, but they'll speak more naturally. And I think that's really important because then you get a better window into their mind. If you've seen them for the first time on the witness stand and they're in a coat and tie and you're in a suit, there's enough of a barrier there that the chances of getting unfiltered, accurate information, I think, are next to nothing.
Right. was there, what question did I want to ask? But at what point, you know what I'm thinking of? I'm thinking of My Cousin Vinny. You know, I'm genuinely thinking about, like, you know how he takes one witness basically one by one, and
the screen,
darling,
right?
Yeah,
maybe it's time for a new set of prescriptions.
New set of glasses,
right.
Or the whole thing with the grits,
yeah.
right? What was it that convinced you guys like they were just wrong?
So there was one witness in particular who was behind the right-way driver traveling east to west, but a good ways behind, eighth of a mile, quarter mile. So he saw the accident unfolding up front, but it was far enough away that he didn't see everything close up. And he described this, he saw it about to happen. He says, oh my God, he can see that they're not going to avoid each other. He sees the impact. He sees both cars, full frontal collision. I mean, the cars were just destroyed. The whole front end was gone. They instantly explode into flames. There's no chance of getting either driver out. Terrible, terrible thing to witness. And one of the cars was slightly off center, so one of the cars spun and spun and spun. And he was adamant, Sharif, absolutely adamant. And I'm sure it was very traumatic for him, right? Nobody wants to see that. But he was adamant that as that car was spinning, he saw the headlights going round and round and round. And the headlights were gone. I mean, the hood was gone, the grill was gone, the front end was gone. There weren't any headlights left. There was nothing left of these cars. That was the memory he had constructed, not the one he actually saw. And at that point, it became pretty clear to me that as well-meaning as these witnesses were, the information they gave the police officers was as much reaction to a traumatic event as it was actual observations.
At any point, did you ever notice that, like, maybe the investigation was flawed in the sense, and what do I mean by that? What I mean is, like, interviewing a witness is a skill in and of itself. If you give them information that they probably shouldn't be privy to, that very well can sweat or skew their testimony, right? Or their recollection. Or you interview people in groups and all that stuff. Did you guys notice any of that?
Yeah. So if you get four witnesses together on the side of the road late at night,
right, and ask them what happened,
and they're literally standing there together, the chances of one of them saying, I saw something different than the other three, are almost zero. So what happens in a circumstance like that is the one who's most certain gives his or her version of the story, and everybody else remembers what they saw that was not inconsistent with that and nods and says, yeah, that's right, that's what happened. It's really fascinating. If you, there's an old story, another podcast about Fry, the guy who, the Fry test before Daubert.
Yes.
So that was named after the lie detector inventor. I think he's also involved in like Wonder Woman and the Golden Lasso. He was the creator of that show or something. It's kind of an interesting legal cultural thing, but he used to teach a class, big seminar, and his first day of class, he would get all the students seated and he'd start his lecture, and someone would burst in from stage right with a weapon and pretend to assault him and then run off the stage. And it was all staged. Nobody really got hurt. And then they would instantly start interviewing the students separately. And they'd get, if there were 100 students, they'd get 100 different stories. It was a gun. It was a knife. He had a black shirt. He had a red shirt. He was dark complected. He was light skinned, completely different. And it's just, we all see different stuff. But if you brought people together, they all kind of synthesized around one story. His point was that our perceptions are really malleable. And I think that's right.
They are. And I think we naturally give our perceptions more credit than they deserve.
A lot more. And we dig into them,
especially
right?
our own, right?
And the more we're challenged about it,
the harder it is to
divest yourself of the sense that you're right.
I mean, so Herbert Stern, in my mind, just an absolute legend, right? And I'm sure I'm not the only one who shares that, but he has a really good video on YouTube that's like a preview of his series on opening statement. And he talks about kind of the story about how, like, you and Buddy are watching a football game and you don't really have any allegiance to either team, neither does your buddy. But there's no way you can sit there and be neutral, right? You're going to ultimately pull for a side. And so he's saying that in the sense of, like, think of a juror listening to an opening statement. They're going to start pulling for a side. But then he says, during the football game, whistle blows, holding. There's a call. Both people are looking at the exact same thing. They're watching the replays. You're saying, that's holding, it's coming back. Your buddy's saying, not a chance, not holding at all. You're looking at the exact same thing. And then the thing I think was most relevant to what you just said, and he says, you're not going to convince your buddy, right? And because it's not about the truth. It's not about the facts. It's about that plus the fact that your buddy has now decided which version is right. So for your buddy to come back and say, no,
Right.
it's actually the other way. It's not that he has to see different facts or view them in a different light. It's he has to tell himself that his first reaction, his first conclusion was wrong. And I think that's when we talk about double down and why in first impressions, opening statements are so important, is because once people make up their mind, you're no longer just asking them to look a different way. You're now asking them to look at their former self and say, hey, you actually got it wrong.
It's a lot harder to backtrack.
That's right.
And that's one of the reasons I think, as a good trial lawyer, if you can kind of spoon feed your case in little bite-sized pieces to the jury and have them take one fact at a time and build their own conclusion from it, you're going to be a lot better off, because then it's their conclusion.
It's theirs. Mm-hmm.
And use that difficulty and backtracking we all have to your advantage. If you tell them, oh, the plaintiff was contributorily negligent, maybe one or two will believe that. But if they don't, you'll never get them there. But if you give them 10 facts that in their mind say, yeah, I wouldn't have done that if I were that person, or I would hope my kid wouldn't do that, then all of a sudden you've got them thinking your way, but they've made up their own mind.
Absolutely.
Once a juror makes up his or her own mind,
it's over for the most part, right?
You're almost
Which
there.
is why, voir dire opening statement are just incredible. It's just so important. And I've actually expanded it. I've stole this from Nick Rowley, who's an exceptional trial lawyer. It's also your first witness, right? I mean, it's everything really, but because voir dire, right? Hopefully you're building some credibility. You're getting the issues out there. You're framing things in the ways that you ask questions, all that stuff. Opening statement, you're telling about your case. Hopefully you're giving them the right facts. Then your first witness, especially if you're a plaintiff, that's your opportunity to put someone who's not you, that's going to have credibility and will support everything you just said for the last hour or two, whatever it was, right? And so a big thing that we like to do is, like, if we can have a police officer and that's our first witness, we've got the weight of the badge.
In a uniform.
Absolutely.
Good haircut.
Looking sharp.
Broad shoulders.
With the shirt stays that we had to wear at VMI, so there's no wrinkles or whatever. But I'm sure, but what you can't see is all the leg hair that is lost because of it. But yeah, so, I mean, it's just so important. So what was it like in this case working it up? Because my understanding is it's ultimately made it to trial.
So it made it to trial.
And why? Like, what was the defense thinking?
Yeah.
Well, I guess I take that back.
Right?
The plaintiff, right.
The plaintiff was thinking. So we got the blood alcohol numbers, and they were good for us. And so the other side then kind of went to battle against the lab and said, well, you mixed up the samples. And they were sort of forced into some corners that were unpleasant to be forced into. And then at the end of the trial, and then the police reconstruction team came in and they redid the whole thing, and they completely reversed their findings. So we had two competing police reports. We had the trooper on the night of the accident saying one thing that was not favorable to us, and a full-blown reconstruction team on the other side saying something that was. And by then we were really confident, but they were so far in that they were going to roll the dice and take a chance. And they still had their four witnesses. That's
what I was going to get to. Did those four witnesses, and I'm guessing the answer is no, but did they ever come back and change their minds?
So I never asked them to, Sharif. And I think one of the great lessons in the case for me was I had witnesses that I sort of knew were wrong. I was really convinced of that. But it was never my goal to get them to admit that.
Right.
Or to embarrass them in front of the jury, or
to make them out to be a liar,
or to make them out to be a liar.
Right.
They weren't lying; they were just mistaken, and so we decided to let them tell their story, and the more they dug in,
right,
and we didn't push them or challenge them, or they told their story. And human nature is to tell the best story you can tell. And where you're lacking specific recollection, fill it in with a blank.
Right.
So at trial, those spinning headlights were high beam, and they were blinding the guy, and they were round and round and round. And we had our reconstructionist who couldn't testify, but who made scale models of the vehicles before and after the crash. We had the scale models of the crushed cars without any front end. And as that witness was describing what he remembered, we were holding up a scale model, and I remember two of the jurors looking at me and nodding, and they knew exactly what was wrong with this guy's testimony.
How did you get ahead of their testimony? Like, because I imagine that either an opening or at some point, or even I'm sure maybe even parts of the jury selection, there had to be something to frame it or to preview this issue rather than just wait till cross.
Yeah, so we had two things. We had two things that were locked in time, written in stone, so to speak. One was that debris field,
Right.
and the other was that blood alcohol test. And those were sort of instantaneous, irrefutable, concrete, tangible evidence that gave us license to call into question the eyewitnesses.
When you did call them into question, though, was it something along the lines of, guys, you're going to hear from four people. They're going to go take that stand. They're going to raise their right hand, and they're going to tell you what they believe they saw.
It was that, and it was a picture of an oncoming car at night that was white. And so we could say, they're going to say the wrong way car was white. And we could point to those blinding headlights. And of course they thought the oncoming wrong way car was white. They're going to say that the right way car was red, and there was a car with taillights. Because every car from a distance going the right way looks red. And
Right, because of the tail. Yeah.
because of the taillights.
That's right.
And again, we weren't asking the jurors to disbelieve them at that point. We were just saying, keep an open mind until you see all the physical evidence. And when you do, we'll come back and we'll look at what the witnesses say and how that fits in.
I like that. No, that makes a lot of sense.
And
Because
I
you're
think,
not gonna
I think
win
most
if you-
jurors are going to be
Yeah.
patient. Now they're sitting on the edge of their seats, and they're waiting a little bit, and they know there's more to the story, and it gives you a little license to be a little more skeptical.
Well, and also it sounds like in doing so, you guys empowered the jury to be like, listen, like, we want you to really focus and get to the truth here. And it's not going to be apparent just off the bat. It may not be what's been told to you, right? You are the detectives in this case. Mark Lanier, an incredible trial lawyer right out of Texas, he has an opening that I've watched too many times. My wife, so the joke at my house is while we're on the couch at night watching TV, I say we, it's not really we. It's my wife is watching something like Love Island, just horrendous TV. And I'm like on the computer.
She might be listening to this. You better be careful.
She's told me, listen, Sharif, she's like, I love you, but you do a lot of these podcasts and
She's got better things to
she's
do.
got better things to do. And I'm on the couch on my laptop, like watching like Mark Lanier and do his opening statement and on a baby talc case against Johnson & Johnson. I'm like having the time of my life. But in that opening statement, and it's fantastic, it's like an hour long, but it's truly, truly exceptional. I mean, he empowers a jury. It was in St. Louis. He goes, you are CSI St. Louis during this trial. It is your job to peel through all the mess and to figure out what happened. And it sounds like you guys kind of did something similar.
We did that, and I think Mark would say, what was Mark's recent big victory? Was he the social media?
It was a social media, against at least two of them. Meta and maybe YouTube. I think there was 4 and 2 of them settled out.
Mark's done well for himself.
Oh my gosh, that guy's incredible.
But I think he's tapped into the fact that what jurors know about courtrooms are what they see on CSI or those shows. And I think they want science and they demand it. So that's one more reason not to come in with a foregone conclusion. Give them the facts and let them play detective. And if you can give them some blood alcohol evidence, and you can give them some physics, and you can give them some cell phone tower data, which we had.
Well, and that visual. I mean, the power of visuals,
yeah.
right? You're holding up a model of a car that doesn't have headlights.
Right.
And yet you've got, how do you rectify that with that witness testimony, juror, right? You can't.
And you never have to call that witness
a liar
or stupid or
Yeah.
conniving or anything like that. In fact, I think the more sympathy you express for that witness, the better, because keep this in mind, every juror is going to kind of associate with that witness. That witness is the only person in the courtroom who's not being paid to be there.
Right.
And there, but for the grace of God, go I. And if I see a lawyer being a jerk to somebody else who just walks in off the street, I might be skeptical what that lawyer's selling.
Absolutely. Absolutely. Yeah. The idea that you see that an effective lawyer is like hammering someone in a courtroom, it's not reality. The best lawyers, trial lawyers I know, are the kindest people in the courtroom, kindest people outside the.
There's a time and a place to.
The jury's got to give you permission, though.
But the jury's got to give you permission, and you can't misplay that card, right? You've got to. If you're that guy when you shouldn't be that guy, it's going to be a long day for your client.
Absolutely.
And so one of the things that I think is really helpful when a witness gets on the stand is to figure out, where does this witness want to go on his own if we let him? The eyewitness wants to be respected and revered and not questioned. The cop wants to be an authority figure without being overbearing. And let them go that way. And because they're going to run in that direction. And you just have to figure out how you can use that direction to help your case. We had, later in my career, I was doing a lot of Innocence Project stuff, habeas appeals for prisoners who were challenging their convictions. And there was a bad cop in Norfolk who took advantage of a lot of kids and wound up doing time himself for selling false testimony from the witness stand. Really he was a bad cop. And he always had a partner. And I think most of his partners were good cops. And I don't think most of his partners saw him doing bad things. But every time we would challenge the bad cop's actions, the attorney general would come in with an affidavit from his partner saying, he didn't do that. I never saw him do that. And so you'd have the good cop on the stand. The bad cop was nowhere to be found, right? He's long gone. But the good cop would be saying things like, well, I never saw him do that. But the good cop wants to put a little distance between himself and the bad cop. And so let him put distance between himself, because he doesn't want to be in the room when the bad cop's roughing up a 16-year-old suspect or lying to somebody or taking money from a defendant, all of which this guy did. The good cop wants to say, well, I wasn't with him 24/7. And there were lots of times when I went out to chase down another lead and he was on his own. And that's the direction he wants to go in naturally. So take him there. And before you know it, you've created a chasm between him and his testimony about what he saw or didn't see the bad cop do isn't relevant anymore.
Absolutely. Yeah.
I remember being shocked at one of the first expert witness depositions I saw a pro take. It was Rosie Page was a great trial lawyer in our firm, and I was a very young lawyer, and I was carrying his briefcase at a deposition in a GM case, and he was deposing the primary expert on the plaintiff's side, and I thought he was going to go in there with guns blazing, and he just walked through the expert's methodology, got the materials, asked them to explain things. They respected each other. They were courteous to each other. There was nothing hostile about it at all. But he got everything he needed to cross-examine him later, and it was a really eye-opening lesson for me. Don't be somebody you think you're supposed to be. Be what your client needs you to be.
I think on that, also recognize that like you don't have to win every witness, right? Like I think young lawyers, and I mean I'm still one of them, I hope. There's this idea like, well, I gotta beat them up somehow, or I gotta win this point. It's like, and I tell people all the time, we need to have the discipline that you can what do you call it? You can lose a battle but still win the war, right? Like you're not expected to. I mean, there may be a good reason not to cross somebody, right? And you don't have any points to make.
Or just get them off the stand.
Get them off the stand, right? And that may be the best
really
move
effective,
there, right? And so having that kind of long game approach is critical, and so you're not getting lost in the fights, right?
Yeah, I think all of us as trial lawyers probably, when we lose a point, we probably think it hurts more than it does. And
Right.
when we win a point, we probably think it helps a lot more than it does. And it's definitely a rather than a score sheet and tally point by point, it's definitely a general sense I think that jurors have that's much less quantifiable than that.
There's a quote, I don't remember who had it, and who knows, it could be fictional, but it's like something along like jurors or juries are not leaves that aimlessly like float in the wind, right? Like they're just not, right? But I know exactly what you're talking about, Jim. It's, oh crap, that's a good point, and they just scored it, right?
They just scored it.
We're losing. We're losing.
And I'm, and now I'm really angry and frustrated. I'm going to let that show, and I'm going to lash out at this witness. I think it's a natural reaction, but I think it's the wrong one. And there was an old saying from the Army days, you might have heard it: slow is smooth, and smooth is fast. Like the fastest way to get the jury to where you want to go is to just slow down and give them the pieces they need to construct their own conclusion. And once they've got that conclusion, they can hear some stuff to the contrary. Because no trial's 100% one way or the other, right? You're never going to win every point at a trial. The case would never get tried. If that
Well,
were the case.
the only ones that are like that are your pro se criminal defendant cases. Those are. I'm joking, not all of them, but for the most part.
But even there, think about that judge who's got to give that pro se criminal defendant every benefit.
I
of the
know
doubt.
they're horrendous.
And there's nothing harder, right?
No,
if you're trying
I remember
case.
we had one. I was when I did the federal district. I did 2 clerkships, the federal and circuit, and the district one. One of the trials we had was a pro se defendant, and my gosh, it was hard. And it's funny because I think your average person would think, "Oh, they're not defended. That should be a slam dunk." No, it's horrendous because now you've got to like watch out for everything. You can't rely on what you otherwise would, which is the lawyers kind of narrowing in on the important issues.
It's completely unpredictable.
It is.
The judge has given them a much longer leash than they would a lawyer.
Oh my gosh, that was a wild.
It can be painful.
That was a wild trial, if I remember it. But let's get back to your case. What was the verdict?
So the judge had bifurcated it. So the first task was to decide who the wrong way driver was, and the jury came back. And by the end of the trial, I was pretty confident that they were going to come back the right way on that question, and they did. And then we moved on to damages. And Sharif, I really screwed up. I am not kind of embarrassed. I was really embarrassed because I didn't do my client the justice she deserved. We had a bunch of UIM insurance, and we had already convinced our UIM carriers that our guy was the victim, not the wrongdoer. And so they had already tendered their limits. And so it was almost like trying a case with a high-low. Once we got the liability determination, the damages for us, practically speaking, were set because the wrong way driver didn't have any other assets beyond that UIM coverage that we possessed. And so I didn't have a good UIM case planned, and I realized as soon as that happened, my client really needed the chance to vindicate her husband's memory.
It wasn't about, I get what you're saying.
And it was really important to her that the jury say, my husband was not the wrong way driver and the drunk killed him. But it was equally important for her to tell them what a great guy he was. And I didn't do what I should have done in that regard. So, I think too often we go into trial thinking about what we need to win it. And I knew where the finish line was, and I was going to stop at the finish line. And I needed to run a little bit past that for her sake, and didn't do that. So if she's listening, I apologize.
Well, I'm sure she's very happy that you took a case that most people would think very long and hard about taking and got a good result, objectively. Your comment brings up a really important point. Our firm, plaintiff's personal injury exclusively. We don't really touch med mal, nursing home. We do take a lot of the more nuanced, challenging, like crime victim type work. And I can tell you, I can't think of a single client. And I'm sure there's got to be one, but they call up and they say, you know what, I just want money. I want a settlement check.
Yeah.
And I have the formula that but what I've kind of come to believe is that clients have 3 goals. And because of that, we have 3 goals with our cases. They want accountability, first and foremost. At a minimum, they want someone to say, you know what, I'm sorry. This shouldn't have happened to you. I was wrong. Be it the individual, the corporate entity. Two, and I hear this all the time, it's, I want to make sure that this doesn't happen again to somebody else, right? And they want that public safety piece, that deterrence. And three, very rarely like, well, I want this amount of money, right? People are almost sheepish when they even think about this idea of money, right? And so the way that we phrase it is they're not asking for money. They're asking for, which I know sounds ludicrous. Like I'll tell people these cases, while they're all about money, they have nothing to do with money, because money is symbolic for the value that's being recognized for what's been taken from the person's health and quality of life, or in the wrongful death situation, that their loved one, that relationship had value, and it had real value. And the only tool that we have, right, is currency. And so it's that recognition. And so I've found that, and I think what you're saying is just so important. There is a cathartic effect, I think, for some to hear a jury say, what happened to you was wrong and what you lost mattered. And that's what a verdict can do.
And I suspect you've never had a client come to you after the fact and say, it was worth it. The amount of money I got makes up for the loss, whatever it might have been. Instead, but you probably have had clients who didn't get what they deserved, but are still grateful for the opportunity to put on their case.
I've had criminal cases in which I've lost, and they're going to jail.
They're
still grateful. And I still remember it was an army. There was an army. This guy didn't go to jail, but I mean, he lost his career. Well, actually, I think it ended up working out for him because we appealed and there was an error. But I wasn't ultimately the one that got the vindication. It was one of my colleagues. I had already PCS'd. But anyways, I remember I lost this admin set board, and which is like for our listeners, that's like a mini jury trial with board panel of officers, and it's administrative separation, so it's not criminal, but the person's going to lose their job, right? And it's more than a job for service members. It's for some of them, it's right. For
and
many
they're
of
going to
them,
leave with a less than honorable, probably.
Yeah, I forgot which one this was, but it was like I forgot what it was. But I remember I losing. I felt so bad, and we went out to the parking lot, and I remember the guy being like, you fought for me, and like that mattered. And I've never. I mean, I don't know how many years it's been since then, but I mean, the fact that I still remember that means just people want an advocate. They want someone who is going to believe in them, who's going to put in the work, and is going to fight like hell. And we can't control the result, and we never will control the result. But that effort, I think, is, as you said, is always appreciated.
And I think especially if you do criminal law or you do some pro bono stuff, it's a superpower you got that you should be aware of. A lot of times you're helping people who have never had an advocate and have never had anybody go to bat for them, right? They didn't have that support at home that you grew up with or I grew up with, and they didn't have that special coach or teacher or whomever pushing them to be better. And the first time they see it is after they get in trouble when someone is assigned to their case. And I remember I'll start the story at the end. I was at this Innocence Project fundraiser event, and somebody's up on stage, one of my former clients, and he's now released, and he's wearing civvies up there instead of the prison garb I met him in. And he's asked, what was it like walking out of prison when you got released? He said, I don't really remember that. Let me tell you what I do remember. I remember when the team walked into my jail cell and said, all right, this is what we're going to do, and we're taking your case, and this is how we're going to win it. And he said, they walked out, and for the first time I had warriors working for me and helping me. And it was like, that was years before we won the case. But all he needed was somebody to have confidence in him, to help him up, to say they'd be with him. And you can do that whether you're helping somebody out of an abusive relationship or a bad apartment lease or whatever the case is. Lawyers need to do that, no matter what they do full time.
And it's kind of a reminder that like these aren't files on a desk; these are human beings,
right? And some of them are files, but usually there's something behind that.
Yeah, I mean, and this is their only case, right? And this has been a lot of fun, Jim.
Well, thanks for having me.
We're not done yet. I got another question for you. So, question that I always ask. It's my favorite question. Knowing all that you know now, you could go back in time to when you were graduating law school and give yourself some advice, hopefully that you listen to, because I know my old self, I wouldn't have listened to it, even if it was great advice, because I was just so stubborn. What would you tell yourself?
It's a good question. I don't spend a lot of time looking backwards. I probably should do more of it. But my brother-in-law is a lawyer, and he told me once something that resonated. He said, whatever you're doing, you need to figure out what your objective is. You want to support the family, that's fine. It can be that simple. Or you want to be a great trial lawyer, that's fine. But if you're not spending every day thinking about how is my current job helping me do what I really want to do, and if you're confusing your current job's expectations of you as your own goals, once you lose sight of your goals and substitute somebody else's, those are lawyers, I think, who lose the script, right? And it's easy if you go to we're all competitive. We all are used to doing better than average, maybe on the team or in the military or in the classroom or whatever. If you get to a firm and they put a set of objectives in front of you, bill this number of hours, make partner in this number of years, don't ever confuse those gateways for your own objectives. And if you're in a place where whatever it is you truly want to do is the place is making that more likely, you're in the right place. And if you're in a place where it's not making it more likely, you ought to be looking around for another place. You should always be looking, even if you're really happy. And it's not that I didn't do that, but I think I could have been more deliberate about asking those questions periodically. And we should all probably be more deliberate about that.
No, that's great advice. Well, Jim, this has been fun. And Jim, you're mediating now with the McCammon Group, right? So
I am,
handling a lot of injury cases, I imagine, and elsewhere.
Call McCammon, a lot of injury cases, a lot of commercial cases, insurance coverage, construction, that kind of thing. So the stuff I did for 30 years, and all the scar tissue that I acquired in those losing trial efforts, and a few of the winning trial efforts are paying dividends because I can hopefully ask some questions that make you think about your case a little bit differently. And I know you're focused on the courtroom. That's great, but when there's a case to mediate, let me know, and we'll do our best to help you get it resolved.
Absolutely. Now, are you focused on Virginia? You're doing it all over?
One of the reasons I wanted to mediate is so that I could focus more on Virginia. It got to a point at the firm where the phone would ring from Los Angeles or Chicago, and I'd wind up unexpectedly there for a few months or a year, and I kind of had enough of that. I got enough Marriott points right now. Sure.
Good. Are you a part of the M Club?
I'm
Gray at our firm. Gray, my partner, he is a proud member of the Marriott M Club. So.
One year, the first, and it may have been the only Christmas present I got, was a cutting board from the hotel that I'd been staying at far too much that year. And I decided at that point that I wanted to do more Virginia work than
Virginia's fun.
Other places.
It's a cool state.
It is, and the more work you do outside Virginia, the more you realize this is a great place to practice law.
It really is.
It's a good bar. It's a really good bench. It's not ridiculously political, and we're lucky to be lawyers here.
We really are. Well, thank you, Jim.
Thank you, Sharif. I appreciate it.
Thanks for listening to Courtroom Stories and Tactics by RVA Trial Lawyers. Hosted by Sharif Gray and Neale Abuzaki. Please subscribe and leave us a review on Apple Podcasts, Spotify, YouTube, or any major podcast platform. Together, we're building a tribe of trial lawyers to remind the world what human life is truly worth, one verdict at a time.